Good morning, afternoon, and hello. Welcome to our Nonprofit Legal and Policy Trends Update. My name is Max Smith. I'm the Marketing Manager for 501c Services. 501c Services has more than 35 years of experience in providing full-service alternatives to state-run unemployment insurance programs and provides services to more than 1,500 nonprofits nationally. We are the administrator of the 501c Agencies Trust, which offers a comprehensive suite of risk management services and multiple stop-loss protection solutions for our 501c3 nonprofit members. We also have UI Insure, a first-dollar unemployment insurance program, not only for just nonprofits, but government entities and tribally owned businesses as well. Many of you on today's webcast are already working with us, and I thank you very much for doing so. Today's program is brought to you in coordination with Independent Sector, our friends over at Independent Sector, I should say. Many of you, like us, are members of Independent Sector. We'd like to thank them for being part of today's program and definitely for all the hard work their staff has been putting in this year. With all the policy and tax changes being worked on right now in D.C., our friends at Independent Sector have been advocating for the nonprofit sector to make sure that any changes are positive changes, not only for nonprofits, but for the people and the missions they serve. So we appreciate them doing that for us, as usual. A little bit of housekeeping before we get started, and then I will introduce you guys to Jerry and Jamie. If you have any questions, please feel free to use the questions tab of your GoToWebinar screen. We'll take questions as we go. We will also hold questions towards the end. So we're going to take questions throughout. The subject matter is pretty diverse, so if we're talking about one thing at the beginning of the hour, we don't want you to have to wait until the end of the hour to get an answer. So I'll interrupt the guys as they go with pertinent questions. So please shoot those to us as you have them. The materials. Following today's session, you will get an email from me with a copy of the slides and with a copy of the video for today's presentation. So you'll get that about 60 minutes following our session today. We also have a number of recertification credits for today's webinar. If you need those types of credits for your personal professional certifications, there's a post-event survey that you need to fill out for me. You'll answer a couple of questions about how well we did and then indicate to me which recertification credits you need. And then I'll send those out to you all by the end of the week. Also, we do this monthly. Actually, we do it multiple times a month for our nonprofit members, but we open up one a month for everybody, and this is our last one of the year, December. We're already getting next year's schedule together, so if you like what you heard today, please come back and join us anytime. Our sessions are always free. So with all that, all the commercials and all the details out of the way, I'm going to go ahead and introduce you all to my friends, Jamie and Jerry. How are you guys doing this morning?
Fine, thank you, Max.
Thanks, Mac. Doing well.
All right, we'll start with Jerry. Jerry's counsel for Howe Hutton here in Washington, D.C. He has more than 35 years of experience in the practice of employment law and representation of nonprofit organizations in both Maryland and the District of Columbia. Jamie is with Independent Sector. He's the Director of Public Policy Strategy and Operations. He leads the strategic planning and advocacy efforts for the Public Policy Department. So those are our panelists for today. Jerry's going to take it off. He's going to cover some legal things that you all need to know that happened in 2017 and also talk a little bit about what to expect next year in 2018. Jerry, go ahead and start.
Okay, thank you, Mac. And we got the first slide up there about the update. There are four things. 2018 should prove to be interesting, to say the least. There are four things that I want to focus on today. One is trends in anti-discrimination law. Second is trends in national labor relations law. Third is the issue about mandatory arbitration. And the fourth is a movement toward banning confidentiality and non-compete agreements. So to start off with the anti-discrimination, a couple of things. Right now, in fact, the Supreme Court heard arguments on Tuesday. There's a case before the Supreme Court. I'm sure you're familiar with it from the newspaper, the bakery case, Masterpiece Cake Shop and Colorado Civil Rights. Basically, a gay couple went into a bakery in Colorado and asked the guy to make them a cake, and he refused because his religious beliefs condemn same-sex marriage. And his argument before the Supreme Court is, this is a matter that, number one, he's an artist. He said, if you went in there and just bought a bag of cookies off the shelf, no problem. But when you ask me to create something, I'm an artist, and this implies approval of same-sex marriage. It violates my religious beliefs, and therefore I'm not going to do it. So he cast it as a First Amendment issue. Now, the concern that I have, and we'll have to see if this comes to pass or not, but let's say that the baker is successful in this case, and the Supreme Court says, yes, your religious beliefs trump any anti-discrimination laws. My concern or question is, okay, how does that impact the workforce? To illustrate the point, suppose that you own the bakery. You're the owner of the bakery, and this guy works for you. And you come to him and say, I want you to make a wedding cake for Jim and Jerry, and he says no. It violates my religious beliefs. Well, under Title VII, anti-discrimination law, you're supposed to accommodate, make reasonable accommodations to the religious beliefs of employees. So will this case, if the Supreme Court decides that the baker in this case doesn't have to make the cake because of his religious beliefs, how's that going to apply to employees? Are you going to be in a situation where your employees can say, no, I'm not going to do something because it violates my religious beliefs? And then are you going to be able to simply fire that employee for insubordination, or are you going to have a potential religious discrimination claim on your hands? So we have to see how that plays out. Next slide, please. Okay, and then the Department of Justice, with the change of administrations, has taken a position rescinding the Obama-era policy on gender discrimination. So this could go up to the Supreme Court too. Now again, this is not a very simple issue. There's arguments on both sides. But number one, Title VII, federal anti-discrimination, prohibits discrimination on the basis of sex, race, religion, other protected categories. Title VII, I don't think you can debate this. Title VII does not address either sexual orientation or gender identity. Now, over the past 50 years, the courts, and you could take different positions on this, but the courts have done cartwheels or twisted themselves into pretzels in order to force the language of Title VII to cover situations which have evolved and developed over the last 50 years in terms of sexual orientation and gender identity. But I think the fact of the matter is, it's debatable, but the fact of the matter is, if you read Title VII literally, these two areas, sexual orientation and gender identity, are not covered. So arguably, this rescission of the previous administration's policy that Title VII or anti-discrimination law covers gender identity or sexual orientation is legitimate under the statute. Now, you have to take into account state and even local anti-discrimination statutes. If they are broader, if a state or even local county or city statute prohibits discrimination on the basis of gender identity or sexual orientation, et cetera, you have to comply with it. But on the federal level, that's a big debate, and that's something that may get resolved in 2018 if it comes up before the Supreme Court. So that was that's the issue there about the gender identity. Mac, if you could, the next slide. Okay, well, we've already covered that one. I was just talking about that. As I said, Title VII clearly prohibits discrimination on the basis of sex, meaning gender. It does not cover, by its terms, literally, does not cover gender identity or sexual orientation. The courts are split on it. Courts of appeals. Some courts say sexual orientation is covered on the basis of so-called sexual stereotyping. That was a case decided back in the 80s, I think Hopkins versus Price Waterhouse. And then there are some cases that talk about, say, Title VII covers sex discrimination. Sex means gender. So depending on how somebody, so somebody identifies with one gender rather than another, if someone was anatomically or biologically born male and has transformed into a female and is discriminated on that basis, Title VII covers it. Other cases take the position, no, Title VII does not cover gender identity or sexual orientation. So that is going to be a big debate, a big issue in 2018. Right now, for example, I've seen some articles that talk about there being as many as 5 different genders: male, female, transgender, female homosexual, male homosexual, etc. So it's, to say the least, it's a very confusing and messing area, but it is going to be an issue in 2018, and right now there's no clear or definite answer to it. As I said a minute ago, if you have a state law that prohibits discrimination on the basis of gender identity or sexual orientation, you have to comply with that. My own personal opinion as an attorney, if I were an attorney advising a client, I would say, maybe this is very conservative advice, but I would say play it safe, play it conservatively, act as if, assume these categories are going to be protected, and do not engage in any sort of discriminatory or adverse conduct against an employee or applicant on the basis of the person's identity or sexual orientation. I think sexual orientation is clearer. More and more statutes on the state and local level are explicitly prohibiting discrimination on the basis of sexual orientation. Gender identity is, I think, is in development. Okay, Matt, if you can go to the next slide, please. All right, now, as everybody knows, if you, unless you don't read the paper or watch the news or something, you know, the issue of sexual harassment has just exploded. Now, coincidentally, this year, the EEOC undertook a massive study and a huge report on basically updating the law of sexual harassment, how to deal with it from a practical point of view, what are effective policies, etc. And one issue that is addressed in this report, which I thought was highly relevant for what's going on right now, and looks like it's going to continue, if not accelerate, in 2018, is this concept of the so-called superstar harasser. Now, I think two points. Number one, it seems to me that the people we read about and see in the news, you know, these movie moguls and actors and corporate titans and politicians, et cetera, they inhabit a different world from the rest of us. You know, most of us don't have $25 million or $10 million a year contracts that are guaranteed for 4 years and have access to the resources that they do. So in that sense, as I said, I think these people are in an entirely different world. But in a different sense, which is more to, let's say, the ordinary world, you do have situations in which a company, an employer, an organization will regard somebody as so important to that organization for whatever reason, has an absolutely unique skill, is a top-notch lobbyist, is a super fundraiser, works wonders, whatever the talent or reason is, that person is virtually indispensable to the organization, and therefore cannot be touched or has to be let alone. And to some extent, you see this in some of these cases with these movie personalities, or, you know, politicians or something, or corporate CEOs. He or she is so important or so powerful, can make or break my career. You just have to live with it. That's Joe being Joe, et cetera, et cetera. What the EEOC is saying is this, that a person's status within the organization carries no exemption or no special treatment. And it cites one study, of course, you can cite a study that proves virtually anything, but it cites one study that says actually, even from an economic point of view, a company is worse off tolerating harassment and dealing with harassment even by a star performer than it is if it dealt with the quote superstar harasser, whatever dealing with it means, firing the person, whatever it means. If this trend continues of more and more people coming forward against more and more individuals in more and more fields of endeavors, eventually it could filter down, and you're going to have to address the issue of the behavior of a quote-unquote star performer. And basically what the law is saying is that superstar status does not confer any immunity or any exemptions. So if you have allegations of harassment, even if it's by the top performer or somebody who's indispensable to the organization, you are going to have to deal with that. Now, having said that, just to make a quick comment, you have to strike a balance. Again, this is my personal opinion, based on my practice as an attorney and the law, but I recognize people may disagree with it. Some of these cases, I think, represent an overreaction. In your workplace, for example, if somebody came forward, well, let me give you an actual case. I'm working on this right now. We had a situation in which a member of an organization came forward to one of the directors in the organization and said, over a year ago, one of your employees kissed me against my will. And at the time, I felt like I had to acquiesce because this is an important person. He could affect my career, so I let him kiss me. All right, that's fine. Now, in my opinion, it would definitely be an overreaction for the organization simply to fire that person. From a strictly legal point of view, there's a statute of limitations. Any complaints have to be brought within 300 days of when they occurred. So if you have a person coming forward with an allegation or a complaint that's 12, 15, 18 months old, the statute of limitations expired. Number two, if you choose to address the complaint, the EEOC requires a quote-unquote prompt and thorough investigation. So no matter how open and shut the case may be, you need to do an investigation. You've taken a statement from the person who's making the complaint. You need to go to the person who's accused and say, this is what so-and-so said, what happened? And you may need to go back and forth because some of these factors may be subjective, memories may differ, et cetera, et cetera. And then the third point, again, from the point of view of sexual harassment law, the employer has an obligation to remedy any harassment or any unlawful activity that has been uncovered. The employer has a duty to remedy that, and the remedy has to be designed to put an end to the objectionable conduct, but also, and again, this is straight from the EEOC's guidance, but also the remedy should be, or the punishment, if it's determined that the person engaged in illegal harassment, should be proportional to the offense. So in a case like this, arguably, and I emphasize arguable because I think there's a broad range of activities, a broad range of responses here. Arguably, in a case like that, where you had a situation, number one, that occurred over a year ago, number two was an isolated incident. I mean, both parties agree that this happened once and never ever happened again. And it was an unwelcome touching, I mean, a kiss, but it didn't rise to the level, let's say, of an assault or a rape or something of that sort. Arguably, a proportionate discipline might not necessarily be termination of that employee, but perhaps a warning, maybe some sort of punitive action, a demotion, or you don't get a raise or something of that sort. But in any event, when you're confronted, what I'm trying to say is when you're confronted with a sexual harassment allegation, if you are the employer, you're the organization, my advice is don't overreact. You take a statement, you do an investigation, you make credibility determinations, and then you decide on a remedy that is going to put a stop to the objectionable conduct and is also going to be proportional. So if we can, so that's the point there about the so-called super harasser. Mac, if we could, the next slide. Now, the National Labor Relations Act is getting to be, from my perspective as an attorney representing employers, the National Labor Relations Act, National Labor Relations Board, I don't know if this is going to change in 2018, with the change in administrations and emphasis, etc. But it has, the NLRB has been very active and assertive and aggressive in the private sector in several respects that, that we're going to cover in this presentation. By way of background, forgive me if you're already aware of this, but you have the National Labor Relations Act. A lot of people think that just applies to unions. It does not. It does not apply simply to unions. Section 7 of the Act guarantees employees, all employees, whether they belong to union or not, all employees, the right to discuss their terms and conditions of employment, including wages, hours, et cetera, et cetera. Under the authority, and Section 8 of the National Labor Relations Act makes it an unfair labor practice, and therefore illegal, to interfere with an employee's Section 7 rights. So under Section 7, I have the right to engage in concerted activity with other employees concerning the terms and conditions of my employment. And under Section 8, if you, the employer, retaliate against me for exercising that right, you're violating the law. So under the authority of Section 7 and 8, the NLRB has gone after all sorts of policies and practices of private sector employers, as I said, totally irrespective of whether or not the employees are represented by a union. Nonprofit, probably 98% of them, there's no union representation. And this has manifested itself in a couple of areas. One is social media policies. The NLRB has found any number of corporate social media policies to violate the National Labor Relations Act on the ground that certain provisions of the policy, quote unquote, chill employees' rights to engage in protected concerted activity. So if you have a social media policy that says you can't disparage the company, you can't post a picture of yourself in a company uniform, you can't criticize your manager, you can't complain about your working conditions or how much you're paid, or you can't go on Facebook or Twitter or these other places and say what a lousy, terrible place this is to work, et cetera, those policies violate the National Labor Relations Act. And if you enforce them, then you run the risk of being found in violation of the NLRA. So under the authority of Section 7, the board has struck down any number of employer policies in the personnel manual. Likewise, if you have a provision in your personnel manual that employees, let's say under your sexual harassment policy, and we'll get to this in a minute. Let's say your sexual harassment policy says if there's a sexual harassment investigation going on, you may not discuss it with anyone else. The NLRB takes the position that violates the National Labor Relations Act because it prohibits me from discussing a work situation with co-employees. So you have a direct tension and contradiction between the EOC and the National Labor Relations Board. Two agencies are trying to work out an accommodation. There's a direct contradiction there. And furthermore, the NLRB takes the position that you can't remedy any deficiencies in your personnel policies or your social media policies simply by putting in a disclaimer that says nothing in this policy is intended to interfere with your rights under the National Labor Relations Act. So the problem is, if you're an organization trying to articulate a social media policy or other workplace policies, you really don't know for sure which side of the fence your policy is going to fall on. If it's examined by the NLRB, if the board is going to say this policy is fine, or the board is going to say it violates Section 8. And the lawyers are laboring under the same handicap. We can't be 100% certain either in advising the client, well, this policy is okay or this one isn't. It's almost like you have to find a policy that the Labor Relations Board has approved and say, well, okay, they've approved this one, so I guess we can use this one with appropriate modification. So that's one area that the Labor Relations Board is becoming very active. If we could go to the next slide, Matt, this is a highly contested issue, and it's going to be an issue in the coming year. And it's basically this, and again, it's a fundamental conflict between two sets of statutes and two public policies. And basically, it's this whole issue of mandatory arbitration. All right? Now, you have the Federal Arbitration Act, and you have Supreme Court opinions that say arbitration agreements are enforceable. So you can force people, you can compel people to arbitrate discrimination claims or any other employment claim, and waive their right to file an action in court, whether on an individual basis or class action basis. Now, on the other hand, the form and structure of Title VII envisions, number one, an administrative proceeding before the EOC, and then if that doesn't work out, if it doesn't result in conciliation, under the statute, the employee's right to go to court, to sue in court to enforce Title VII. So you have a flat-out contradiction. You have the Supreme Court saying under the Federal Arbitration Act, you can force somebody to arbitrate discrimination claims. Under Title VII, you have the EOC arguing that such compulsory arbitration clauses violate Title VII. So that is an issue that there are now 3 cases, as this slide identifies. There's 3 cases now in front of the Supreme Court on this issue of to what extent, if any, can employers compel arbitration and waiver of class actions under the Arbitration Act vis-a-vis other statutes like the National Labor Relations Act, or Title VII. Okay, so we can go to the next slide. Okay, I think that does the. Oh, the other point I wanted to mention. On the non-compete agreements. Partially, I think, as a result of some cases, and also, again, this big issue about sexual harassment, et cetera. There's a trend, which I think is going to continue in 2018, whatever you want to call it, a trend or a movement to outlaw, to make illegal confidentiality agreements in sexual harassment settlement agreements, and also a separate issue, but also to make illegal non-compete agreements. Now, with respect to confidentiality agreements, again, if you look at the newspapers and the news, it's commonly said that these confidentiality agreements work against the victim because it prevents him or her from telling the story or saying what happened or warning others. I think you have to take into consideration that, at least in some cases, the confidentiality clause may be as protective of the victim as it is of the employer and the victim, him or herself, for various reasons, personal, professional, whatever, may want a confidentiality clause in there. But there is a trend, there is a movement to ban confidentiality clauses. And this raises another issue, because right now, as it is, settlement agreements are extremely restricted as they are. You can't prevent somebody from filing a charge with the EOC, for example, regardless of settlement agreement. You have to meet strict criteria for waivers. So some employers are saying, what's a settlement agreement even worth? I'm going to pay somebody $10, $30, $50,000 to settle a case, and that person can turn around and sue in the EOC anyway, and the EOC can still investigate it. So the more restrictions you place on these settlement agreements, arguably, the less valuable you make them to employers and less willing to offer. So we have to see how that trend plays out. And the same thing with the non-compete agreements. There's a couple of states, I mentioned on California, North Dakota, which have actually either restrict or ban non-compete agreements, either by saying they can only apply to a certain level of employee or somebody with a special skill, etc., or possibly even saying they're not allowed, period. So with that, I'll conclude. If anybody has any questions, I'll try and answer them. Or Mac, turn it back to you.
Thank you, sir. Good. We're going to go ahead and go on to Jamie. We do have some questions in there, but we can cover them towards the end here. So Jamie, I'm going to go ahead and see if I can give you control of the slides here after I move into your section. All right, you should have that. It should be sending to you now, Jamie.
All right. Well, thanks everyone for taking the time to join the webinar today and for giving me an opportunity to talk a little bit about the policy trends for the sector over 2017 and try to look ahead a bit to 2018. I think there is some underlying overlap with a lot of what Jerry just covered. When you look at the trends broadly and when you consider the kind of environment that we're operating in right now, certainly a lot of challenges on the landscape for us as employers, for us as service providers, and certainly for those that we serve as well. So let's take a look at 2017. So if we think about 2017, what I would say the biggest policy trend of the year has been is this idea of a fundamental reshaping of the size and scope of the federal government. We have new leadership, which has led to a new philosophy. Republicans control the White House, they control the House and the Senate, and the leaders have, from almost January 1, been pushing a new direction for the federal government and how it views its service capacity and core responsibilities to the American public. This has significant implications for the sector, our work, the people we serve. And I want to spend the next few minutes really talking about what this resizing and reshaping has really meant this year. There are a lot of lenses in which to look at this. There are three primary ones if you consider the policies that have been put forward by the administration and Congress: healthcare, spending, and tax. Again, there are many more, and happy to answer questions as we go along, or at the end. I think they can delve down a bit deeper. But if we look at these broader lenses, we see a lot of commonalities. So healthcare, no surprise to anyone if you followed anything in the news over the past year. When President Trump was inaugurated in January, when the new Republican majority took power, there were two big priorities that were put on the table. Among them was a campaign promise to repeal the Affordable Care Act. Later, this became a bigger conversation of how can we repeal and replace the Affordable Care Act, and we'll get into that in just a minute. But this idea of changing the fundamental structure of our healthcare system. There were a number of policy changes sought in two major legislative pushes throughout the year that ultimately failed in the Senate. And among the reasons for that were broader disagreements over this idea of essential health benefits, which right now under the Affordable Care Act, there's a core set of health benefits that must be covered under any health care plan. Certainly there were some issues with cost there and some concerns. Also the issue of Medicaid and what they might want to do with Medicaid moving forward. The expansion process in the Affordable Care Act certainly allowed a number of states to make additional and different choices about how they valued healthcare. And what came as part of one of the most difficult pieces of trying to completely repeal Obamacare during the summer was this idea of what would happen to the states who had made the choice to expand, what would happen to other states that were still considering it. This ultimately led to both bills falling apart in the Senate, not being able to achieve enough votes from the states. Now, I will say for the time being in 2017, at least it does seem that any threats to the Affordable Care Act are over, but that doesn't mean that this won't come back in 2018. I certainly think that's something that we'll see, particularly if Republicans are successful with tax reform, that some additional push on the healthcare side we will see again into next year. And whether or not it will be a direct attack on the Affordable Care Act again, that's certainly unclear. But what is clear is that this fundamental idea of wanting to look at how the federal government approaches healthcare, how it approaches its sort of responsibility to the American public, that is going to remain in question, I think, regardless of what individual policies we may see. We've also had an issue, so after that didn't quite come together for Republican leadership, we saw the issue around the cost-sharing payments that the government does pay to insurance insurers now to help offset the cost of insurance for low-income Americans. The Trump administration made a decision in October to begin to scale back on those payments. Those remain a bit of a source of controversy more broadly, and I talk about this in terms of we look at what's on the table. We look at how how Republican leadership right now is thinking about coverage, how they're thinking about particularly low-income Americans, how that might look. We have heard a bit from Speaker Ryan that they are considering doing entitlement reform into 2018. So how does that piggyback on this idea of changing how the government is supporting healthcare? I think what we also have seen, as part of this on the healthcare space, is looking at the individual health insurance mandate, how that's being treated, considerations with that, and in the tax reform debate, it does seem that it is something that might be on the table for repeal. That will certainly have impacts down the line, and how for the cost of insurance, particularly as the young invincible group may want to opt out, and are raising costs for older Americans. And another issue that has been on the forefront for a number of weeks since it was allowed to expire in September is, of course, the Children's Health Insurance Program. This program does provide low-cost coverage for children whose parents may not qualify or families may not qualify for Medicaid. CHIP authorization is something that remains a big priority for Democrats, and it's something that is complicating a bit the spending debate that we're seeing at the end of the year and how leadership may choose to take advantage of that. So healthcare has been a big piece of how the trends have moved forward. We also want to take a look at spending more broadly. So hopefully, and it's probably hard to forget in some ways, you remember the Budget Control Act of 2011. This, during the first fiscal cliff conversation we had a number of years ago in the Obama administration, really set forward this idea of discretionary spending caps. This world that we're in, that every year there are limitations placed upon how much we can spend on non-defense and defense spending. There have been prior deals that have adjusted these caps that will have allowed for some flexibility for additional spending, particularly on medical research and other key, research and healthcare pieces. The most recent of these deals, put together by Paul Ryan and Patty Murray, actually expired with the conclusion of fiscal year 2017. So we're back in this world, we're back in this environment where discretionary spending caps are playing a big role in how we think about spending. And what we don't have, as opposed to in previous years, is even a divided government where Democrats and Republicans both retain some control, and there's some incentive to want to work this out, to want to try to find some adjustments. Thus far, it does not seem that Republican leaders are as interested in potentially making adjustments to the caps, at least on the non-defense side. And the non-defense spending covers everything from education, healthcare. I think among the most controversial are what is known as the Labor HHS Appropriations Bill. Covers any number of education priorities, healthcare priorities that are not part of mandatory spending. These things will remain very hot button issues, particularly as we get into the end of the year. And it's going to be a very complicated and complex conversation. Democrats do have some leverage, particularly in the Senate, to be able to make some changes and to put forward perhaps some additional spending priorities. I think if you look at what the House and Senate and the President have put forward so far, what they're hoping to do is shift $54 billion away from non-defense spending to defense spending, bolstering the defense budget at the expense of the non-defense budget moving forward. One of these, this is probably one of the biggest issues in terms of how the fight over discretionary caps or caps in general may play out. As part of the Budget Control Act too, and I was remiss not to mention this earlier, if you go over the cap, if there are no statutory changes that are made to allow for adjustments or allow for increases in certain areas, if you do go over the cap, mandatory sequestration is still imposed. And what sequestration would do is to simply just allow across the board cuts on all programs on the non-defense side, for example. And these indiscriminate cuts would not take into account any sort of growth, innovation, or anything else that may have been happening that might have been trending in the right direction in terms of programmatic development. So spending is not in a very good place. And this really is another fundamental shift in philosophical difference that you see from Republican leaders, is that a size and scope of government, what government should pay for, what government should support. The idea, of course, in the broadest terms, the most general terms, is providing for a strong defense certainly is something that is a true priority. How the government treats social programs is something that has been a very interesting piece to watch. What matters beyond healthcare, how education is treated will certainly be things we'll be looking at moving into 2018. And if you look at the budget resolution process this year, and even though the budget resolutions are primarily non-binding, they do set policy priorities for the appropriations committees. But if you look at the House appropriations proposal this year, they put forward over $200 billion in mandatory spending cuts. And I mentioned that Speaker Ryan's talked about doing entitlement reform in 2018, and I think part of this will be looking at ways to cut funding, to cut resources from these broad programs to scale them back. And how does this really impact the nonprofit community? Well, I've been in a number of meetings this year with leaders, with staff of committee, and I think among the most common things that I've heard, and it's been very concerning as well, yes, we understand that we might need to scale back certain programs, but the nonprofit sector is there. You guys will make this up for us. You'll take care of it. I think anyone who's worked in the sector for a while knows that while charitable giving is fantastic, we do a lot with private dollars, but there's no amount of charitable giving that we could incentivize that would make up for that partnership we also have with government. So hearing those things from leadership, from staff who don't truly understand the partnership, the roles that we kind of play together in providing services to communities, uplifting communities, is concerning. It's something we're going to have to take into real account and to push forward and do our best to have better conversations, to provide better information to these leaders moving forward. It's going to be very problematic. And I think if you watch the spending debate at the end of this year, we're currently under a continuing resolution, which means the government's just kind of funded on borrowed time for a while through next Friday. I think this world of continuing resolutions is probably going to continue for a bit. We might get some year-end deal this year that does bolster spending a little bit. I think Democrats getting some leverage in the Senate might be helpful, particularly with the non-defense spending. But moving forward, these very short windows of funding that don't provide a lot in terms of growth, innovation, that really stall out funding are going to make funding considerations, grant considerations very challenging for the government and for organizations as well. It is not what I would call one of the best environments that we could hope for in terms of spending, but it is one of the things that, as an organization, if you are steeply involved, if you have an appropriation that you care a lot about, there's something that really truly impacts your communities, continuing to speak up on that matters. Bringing those stories up to lawmakers. I do think there is a fundamental disconnect between at least leadership now and how government spends money versus the true impact of that, what it means. And it's incumbent upon us to help make that connection. So we talked a bit about healthcare, we talked a bit about spending, and I'm going to spend the last few minutes really talking about the tax side. And this is the side that we at Independent Sector have followed most closely over the past year, and the piece that is making the most news right now as the House and Senate are now in a conference committee and talking about tax reform. We have bills that are on the surface all not that promising for the charitable community, and I'll get into a few details about that in just a moment. But I do want to talk about the process as well. It's easy to look at the broader process to say that perhaps we were not as successful in some ways in rising the level of debate on certain issues, but I think some of the same criticisms you may have seen lobbed against Democrats during the Affordable Care Act debate. Now, some of them, don't quite connect in the same way, but the process of reconciliation, finding ways to shortcut debate in some way, move forward a bit faster than you might otherwise would have on an ordinary debate schedule. It certainly hastened some of the policy developments. And at the end of the day, what comes down to in terms of looking at the tax code, yes, it's about providing relief. Yes, in some ways it's about providing some fundamental changes to the structure, but it's also a resetting of the type of revenue that we need. This is all part of that fundamental shift in the size of government, the scope of government. We take a look at what our responsibility is on the healthcare side. We want to make adjustments. We want to make adjustments to spending, and we want to make adjustments to what's being brought in. So at some level, all three of those align a bit better than they do now. So I'm going to go ahead and move this slide.
You need the tax slide, or you need the next slide?
You got it. Thanks so much, Matt.
Okay, perfect.
It just showed up on my screen a little bit late. I got it. So the Tax Cut and Jobs Act. And I'll go through a few of the details here. One thing, and there'll be a slide coming up that has links to resources that go in much deeper. And happy to have Max send those out as well with recording after. But I'll cover the high fly now, and really happy to answer questions in greater detail as we kind of move forward. But if we look at the Tax Cuts and Jobs Act, we want to take a look, at least from independent sector's perspective, what happens to charitable contributions at the top. And right now, in the bills and what's being debated in conference, the charitable deduction is limited to only those taxpayers who continue to itemize. And if you double the standard deduction, as they're planning to do, if you make some adjustments to the rates, as they are planning to do, you really effectively remove this incentive for giving from roughly 40 million taxpayers. So what does that mean in terms of impact? We're looking at anywhere between 12 and 20 billion per year decline in charitable giving. And this doesn't even include what we might see in reductions in terms of the estate tax. Now, on the Senate bill, the estate tax just weakened. You double the rates. You double the exemption threshold level. The deductions are roughly the same, or the rate is roughly the same as it would be. The House would eliminate it. And the House would eliminate it. And it does seem that the estate tax will survive ultimately, but the weakening will cost charitable giving in terms of charitable bequests. And it's also a big revenue hit to the government to no longer have the estate tax in full force as part of the regime. Whether or not the estate tax changes will be permanent, that remains to be seen, but it certainly will have an effect on giving. I will note that there is an increase, or proposed increase, in the AGI limits for cash contributions. Currently that's set at 50%. The bills would increase it to 60%. We do think that would provide some modest boost in giving, particularly among the roughly to 5 to 9% of taxpayers who would continue to itemize and take advantage of the deduction. But we do not think that would be enough to account for the massive loss that we expect in terms of the tax changes. I also want to talk a minute about the Johnson Amendment. The Johnson Amendment, if you don't know, is a 63-year-old law that has protected nonprofit nonpartisanship. It does prohibit all 501c3 organizations, including churches, even though I think the issue has really been primarily framed in terms of churches, from endorsing candidates or participating in political activity, raising money. The Johnson Amendment has been under assault from President Trump and at least Chairman Brady of the Ways and Means Committee for most of the year. It does seem that any changes to the Johnson Amendment may not happen in the tax reform debate. There was a provision in the House bill that would eliminate the restriction on endorsements for all 501c3s, not just churches, but all C3 organizations. It does seem, at least in terms of a procedural maneuver in the Senate, something called the Byrd Rule, which prohibits certain changes to be made in tax bills, revenue bills that aren't what is considered to be germane if they don't have a revenue impact, or if there's some concern about it, if it's not incidental. And this is pretty technical, but we do think that even if a Johnson Amendment change were to be put in a bill, that the Senate could raise a Byrd objection that would take it out, which is something very helpful. I say that, though, we look at the impetus behind the Johnson Amendment change. A very small group of evangelicals have been pushing for this for much of the year. If we consider that, it doesn't seem that tax reform is going to be the only bite at that apple, and certainly we expect the president and others to bring this up as an issue next year as well. Very quickly, some of the other issues. Unrelated business income, both bills would make some changes to how nonprofits treat unrelated business income. One of the most concerning provisions revolves around fringe benefits and how they may be treated and what actually constitutes as a fringe benefit. There's also proposals for excise taxes on colleges and universities, or the investment income of private colleges and universities. This has limitations for very wealthy endowment investments at this time, although this does seem to be a slippery slope issue moving forward for all colleges and universities. Excise taxes on executive compensation, how this would work for a nonprofit organization for their 5 most highly compensated employees, any of them that have income or salary plus some benefits over $1 million from the organization would be hit with a 20% excise tax on each of the employees over that threshold. The House bill would eliminate private activity bonds. I will say 2 positive notes. The private foundation excise tax, currently in a 2-tiered structure, the House bill would impose a 1.4% flat rate. This issue isn't addressed in the Senate bill. At the same time, the House bill would make some permanent adjustments, or at least allow the IRS to make adjustments to the volunteer mileage rate. Currently, that can only be done through statute. The bill would allow, at least the House bill would allow the IRS to make adjustments based on inflation for volunteer mileage. So again, the resources, I'll make sure to share these with Max so you have them. It takes a look at how the big issues the conference committees are debating that have impact for the charitable sector, the people we serve, and also a dashboard of just very quick check-off issues and how they might be reconciled. So looking ahead in the next year, somewhat tongue-in-cheek, you do see the dumpster fire on your screen. It feels that way a bit in DC sometimes. There's going to be a lot to do, a lot to think about. I've mentioned entitlement reform. Certainly that's on the table. Net neutrality is something maybe no one's paying attention to. If you are, that's fantastic. That could actually, there's going to be some implications with that this week with an expected vote from the FCC. Net neutrality really, at this point in time, if you're not familiar, does provide sort of a more level playing field for internet service providers. They're not allowed to make charges. They're not allowed to do things that would advantage certain areas over others or certain websites. This could be problematic, particularly for folks who have access in rural communities moving forward. We also look at the preparations for the 2020 census. The 2020 census is going to be huge in terms of how we think about our government representation for the next 10 years, how we think about allocation of resources. Right now, the census is very much underfunded and under-resourced. With the vacuum of leadership at the top, there are concerns there. A number of nonprofit organizations are working very hard to address this. If that's anyone on the call, my appreciation to you, that's something the independent sector, I think, will be taking a stronger look at into next year as well. Higher education, public student loan forgiveness. These are issues that kind of remain in the stratosphere as well. There is a bill pending in the House now that would make some changes to how the public student loan forgiveness program would work. Some of these changes are reflected in how perhaps student loans would be calculated and how they would be provided. But certainly from a nonprofit pipeline perspective, having good support in, being able to provide incentives for people to come in to want to work in the sector, perhaps when salaries can't be as high as some of on the private side, this is a great program. More on taxes. Tax reform is not going to be the end of the story. I think there'll be a lot of efforts to change, make adjustments into next year. And of course, spending, this will continue to be a huge issue. So, finally, we think about all of this, and I'll pause just a minute because I know we're running short on time, but what should you do? Stay engaged. Get to know your members of Congress if you don't already. Have conversations. Uplift the voices of those that you serve, and really spend some time, whether or not you have a policy shop. You don't have to have a policy shop. It's not necessary at all. You have the power, you have the ability to do all of this, and that's something that is incumbent on all of us, and it's something that independent sector, we're going to work very hard to help our members and others feel more comfortable and stronger about in 2018. So, Mac, I've crammed a lot in. I'm sorry if I went a bit over, but happy to take any questions.
Okay, I think we have time for probably one question for each of you. We'll go ahead and flash up next month's webinar after the holidays and the new year, and when everybody gets back to their jobs next year. Jerry, talking about the NCA, does the ban and limitations on the NCA apply to nonprofit volunteers as well, or just employees? Can you expand on that a little bit?
I'm sorry, the ban on what?
Amy has put ban limitation on NCA.
Oh, non-compete agreement.
Exactly.
No, that would just apply if there's a policy or law in the state. It would only apply to employees. It wouldn't apply to volunteers. You'd have to look at the state statute. But generally speaking, to answer the question, no, it would only apply to employees, not to volunteers.
Perfect. Yeah, figured that's what that was. But just to clarify.
Yeah,
and
okay.
Jamie, AGI limits for contributions. Is there any change to that to private foundations? Specifically, Mickey's asking about private foundations.
There are no adjustments to that. I believe the cap is at 30% now for private foundations. The cap adjustment was only for cash gifts from 50 to 60, but the actual limitation that said, I think, overall on private foundations was not addressed or has not been addressed in the two bills that are being considered right now.
All right, perfect. All righty. Well, we'll go ahead and conclude that. It was a lot to cover in 60 minutes. I know we went kind of fast and glossed over a lot of stuff. Hopefully, maybe we can have some more in-depth conversations later on. But if you have any questions, please feel free to email me when you get your email later today, and I'll forward them to the guys, and they'll be happy to answer them from here on out. And we will send you the slides and a recording of today's presentation later today. But I want to thank everybody for joining us. Jerry, Jamie, thank you for being here, and hope everybody else has a pleasant holidays ahead and a great remainder to the rest of your week. Thank you, everybody.
Thank you, Mac. Thank you. Bye.